All right, our second case today is case number 25-288, Catherine Wyrick versus Millennial Capital Company, LLC, and Grep Southeast, LLC. Are you Ms. Layton?
Yes.
Ms. Layton, how much time would you like for rebuttal? Standard is 5.
5 minutes, please.
All right, whenever you're ready, ma'am.
Great. Good morning, and may it please the court. I'm Shelby Layton for appellant Catherine Wyrick, and I'm here with my co-counsel Joseph Sternberg. This is a landlord-tenant dispute based on Ms. Wyrick's rights under Florida statutes and her lease with defendants. But the trial court compelled arbitration under a separate agreement Ms. Wyrick had with a different company, RealPage, for her use of its software program. As explained in Ms. Wyrick's brief, there are at least 5 independent reasons that the trial court's order should be reversed. I'm going to focus on 2 main errors that the court made here. First, the court was required by U.S. Supreme Court precedent to address the threshold argument that it was not authorized to compel arbitration under Section 2 of the FAA, but it did not address that issue. Second, the court erroneously delegated to the arbitrator the question whether the delegation clauses in the arbitration agreements could be enforced by defendants as non-signatories. Both of these issues come down to the fact that Ms. Wyrick's claims against her landlords under Florida statutory law simply have nothing to do with her contracts with a third-party software provider. As a result, this court should reverse. I want to start with the Section 2 issue. So binding Supreme Court precedent didn't leave the trial court a choice. It had to address whether this dispute falls within the plain text of Section 2 of the FAA before it could address any of the other issues in the case. That's because a court can't compel arbitration of any case just because the parties agreed to arbitrate. It needs a statutory authority to do so, and here Section 2 of the FAA is what would provide that authority. And the Supreme Court has been crystal clear that that threshold determination has to be made even if the arbitration agreement delegates questions of arbitrability to the arbitrator. In the New Prime case, the court explained that a court can enforce a delegation clause only if the dispute falls within the boundaries of Section 2, because a delegation clause is merely a specialized type of arbitration agreement, and the FAA acts on this additional arbitration agreement just as it does on any other. So if the FAA doesn't apply, the court can't compel arbitration of any question, whether arbitrability or the merits. If the FAA does apply, then the court can look at whether there's an enforceable delegation clause and either proceed to decide arbitrability itself or delegate that question to the arbitrator, depending on the enforceability of the delegation clause. Here, as a matter of plain text interpretation, Section 2 is limited to controversies that arise out of the contract containing the arbitration provision. And here, the controversy does not arise out of the contracts with arbitration provision, which are the contracts with RealPage. And it's important to note that the controversy must meet the arise out of requirement regardless of the arbitration agreement's stated scope. So this is a question about whether the FAA applies, not a question about the scope of the arbitration agreements themselves. And this controversy does not arise out of Ms. Wyrick's contracts with RealPage. RealPage is just a software platform. It's not a defendant here. And Ms. Wyrick does not allege that RealPage violated the law or anything in its contracts with her, nor does she allege that defendants violated the RealPage contracts.
There is a tipsy coachman argument that's made in the answer briefs about the notice being sent to your client coming from a RealPage server. I think you addressed that in the reply brief, but I wanted to give you an opportunity to talk about it here.
Sure. So the email came from an email address that had RealPage in it, but it was sent by defendants, and Ms. Wyrick alleges that defendants violated the law by failing to provide notice of the fee in that email. RealPage was just the software that defendants used to send their email. This is no different than if defendants had used Gmail or Outlook or any other email address to send an email to Ms. Wyrick. Just because they use that software to send the email doesn't mean that they can then enforce the arbitration agreement in Ms. Wyrick's Gmail terms of use or her Outlook terms of use.
Is there a difference based on your claims are based on an agency theory, I think, as it relates to the property manager. The property manager wasn't a signatory to the lease, correct?
Our argument is that, on the merits, is that the property manager is a landlord under the Florida statute at issue. It's not at all based on a contractual argument. And Ms. Wyrick, to the extent her claims are based in any contract, they're based in the lease, which provides for disputes to be resolved in court, not in arbitration. And if defendants wanted to include an arbitration agreement in the lease, they could have done so, and they didn't do that here. And so, again, this really doesn't arise out of the contract, and so Section 2 doesn't apply, and if Section 2 doesn't apply, then the court has no power to compel arbitration of any issues here, including the issues of arbitrability. Assuming this court disagrees and wants to reach those issues, the next question is the trial court's decision to compel arbitration of those arbitrability issues without considering Ms. Wyrick's specific challenges to the delegation clause. And so her first challenge to the delegation clause was about the fact that this is neither defendant signed these agreements with RealPage. They're just between Ms. Wyrick and RealPage. And so her argument is that defendants cannot enforce the delegation clause as non-signatories. And the trial court was required by Supreme Court precedent to address those challenges to the delegation clause before it compelled arbitration. And again, that's because a delegation clause is merely a specialized type of arbitration agreement. So if it's not enforceable, the court can't compel arbitration of the arbitrability issues. And that is from the Supreme Court's Rena Center case, which says that if a party specifically challenges the precise agreement to arbitrate at issue, whether it's the delegation clause or the arbitration agreement as a whole, a court must consider that challenge before ordering compliance with that agreement. And again, in the Coinbase v. Suski case, the U.S. Supreme Court confirmed that in that case, there was a question of which contract applied, and the court said the court has to address whether there is a delegation clause and whether that delegation clause applies before it compels arbitration. If courts didn't have to address challenges to delegation clause, there'd be no principled limit here. For example, Ms. Wyrick could sign an arbitration agreement with Amazon and have packages delivered to her apartment, and just because Amazon has a delegation provision, defendants are saying that Ms. Wyrick would have to go to arbitration to arbitrate the issue of whether Amazon's delegation clause and arbitration agreement apply to this dispute, even though they clearly do not. And this is the same situation as we have with the RealPage agreements.
But counsel, I guess maybe it's two different considerations. One, what does law require a judge, a trial court to do or not do? And another is how broad an agreement actually is. And I think here you agree probably that the agreements at issue are very broad, right?
I don't think I do agree with that. So the RealPage agreement, the one we call the RealPage agreement, which has to do with her application, is both limited to only disputes with RealPage. So on its face, it doesn't apply to this case or any disputes with defendants. So I would say that's a pretty narrow arbitration agreement. And then it's also related to certain disputes that only arise out of aspects of the application process and not the whole, universe of potential disputes. The active building agreement
Well, it talks about all disputes, including those relating to future events pertaining in any way to your client's application for housing at the property under any legal or equitable theory, including claims for breach of contract or statutory claims.
That's right,
How
but
would you
there's
draw that broader?
So there's a key phrase that respectfully you're leaving out, which is the disputes between you and RealPage. And so the way you could draw that broader is to remove that that limitation to only disputes between you and RealPage.
So how does the agreement define what RealPage is?
It defines it as basically a couple different entities, but definitely not defendants. So it's RealPage and its corporate siblings, but not landlords that have nothing to do with RealPage. There's no relationship here other than as a customer between the landlords here and RealPage. They're just buying a software service and using it for just the way you would buy, a Microsoft Word or something like that. And so they're not defined in the definition of RealPage in this contract.
Well, counsel, even setting aside the RealPage agreement for now, looking at the active building agreement, it states any dispute, claim, or controversy, each dispute arising out of or relating to the service, including, and it gives a TCPA claim between you and then RealPage and your apartment community manager, will be resolved exclusively by binding arbitration rather than a court proceeding. Now the phrase any dispute arising out of or relating to the service is quite broad, and a term including that would seem to introduce an example of such a dispute, not a limitation of the exclusivity of that type of dispute, correct?
You mean the TCPA
Correct.
language?
It says including any TCPA claim, so that's not exclusive to that type, correct?
Sure. So there's a couple issues here. First, there's the question of the scope of the agreement, and then there's the question of whether Greystar is a third-party beneficiary of that agreement, and I want to make sure we keep those two questions separate. But in terms of the scope of the agreement, it includes all types of claims arising out of Ms. Wyrick's use of the active building portal, and that would include TCPA claims arising out of the use of the active building portal, but certainly isn't limited to TCPA claims arising out of the use of the active building portal. And here, this dispute does not arise out of her use of the active building portal. There's no allegations in the complaint about the active building portal. There's no allegation that the active building portal has anything to do with what Ms. Wyrick is alleging here. And so even though that's certainly a broad provision, if she were suing RealPage over something related to the active building portal, it would almost definitely be covered by this arbitration provision. But here she's suing her landlords under landlord-tenant law, and so even though it's a broad provision, it still doesn't apply to this particular dispute. And again, you only reach that issue if you first determine the separate Section 2 question, which is not about the scope of these agreements, but is about whether this dispute arises out of the active building agreement itself. And then you mentioned the phrase about the TCPA, so going to the issue about whether Greystar can enforce that agreement as a third-party beneficiary, which they've argued they can, that phrase is the only place where it mentions the apartment community manager is in the clause about the TCPA claims. And so there's no way to read that provision as intending to benefit Greystar more broadly as to the entire agreement. So even if that agreement applied, Greystar would not be able to enforce it.
But why is that the necessary implication? It's giving an example, but arising out of or relating to the service is the broad category. And so why should we read that example as limiting the broad category when it actually just falls within it?
I don't think it's limiting the broad category, but when you're looking specifically for the third-party beneficiary analysis, you're looking at whether the parties intended to benefit the third-party beneficiary. And because they mentioned the apartment community manager only in that one specific instance, I think as a matter of contract interpretation, it should be read to assume that the parties only intended to benefit the apartment community manager in that one instance. Otherwise, they could have said more explicitly, all claims between you and RealPage and your apartment community manager, and left out the specific limitation to the TCPA. So there's no evidence in the language of the agreement that the parties were intending to benefit Greystar as to all claims in the case. And I'll note that even if it was broader than TCPA claims, it talks about claims against RealPage and the apartment community manager, which is not this case. She's not suing RealPage and the apartment community manager. She's just suing the apartment community manager. So there's, again, no evidence that the parties intended to benefit Greystar, and so Greystar can't enforce the agreement. And yeah, I'll reserve the rest of my time for rebuttal. Thanks.
Thank you. We have two appellees. Have you all discussed how you want to split your time?
Yes, Your Honor.
How are you going to do it?
I plan to argue the arguments that are the same between both of Greystar and Millennial, and then I was going to reserve 5 minutes, if possible, to allow any questions for Millennial that are specific to their issue. But otherwise,
Oh, so I understand. So you're going to take 15 minutes and then just ask if there's anything panel related?
Correct, and I'm prepared to address all of the issues that are common to us. There's really only one that isn't, so if there's any specific questions.
Got it.
Is
So
that-
would you enter your appearance and then we'll
Yes.
get started after that?
Good morning, Your Honors. My name is Kristen Fiore, here today on behalf of Applee Greystar. With me here today at council table is Mr. Rob Vargas. He represents Millennial. And as I just said, I'll be presenting the arguments that are common to both Greystar and Millennial. And if the court has any questions, I'd like to reserve 5 minutes for that for Millennial. Your Honors, the trial court found that Ms. Wyrick entered into a valid arbitration agreement. Given the clear and unmistakable evidence of intent to delegate any questions of arbitrability to the arbitrator.
Counsel, what are the limits to delegation?
So limits to what you can put in a delegation clause? I think it's defined by what the parties, what.
So as long as there's what's considered to be mutual consent of the parties, there's no limitation to delegation?
I believe so, unless I could probably surmise of a circumstance that's not applicable in this case where you would agree to delegate the issue of whether there's a valid agreement, for example, and under Florida law and United States Supreme Court case law, we know that that's a question for the court. So I could see a circumstance like that, but generally, as you know, a creature of contract, these are pretty broad, and that's permissible, especially the ones in this case. And
So is the possible injustice from that remedied because of the clarity requirement?
I think so. I think that that has to be clear what the parties are, here we've got Ms. Wyrick. She entered into these arbitration agreements. I know there's some dispute in the record about whether or not she knew what she was signing, but we know that that's not a defense to entering these click-wrap agreements. And so I think she knew that these were broad, or she's charged with knowing that these were broad delegation provisions, and so there's no harm there regarding lack of clarity. And
So really there's two things for the trial judge. Is there a valid contract and is this clear?
I think so. I've not seen it really articulated that way, but I think so. I think the question is, one, is there a valid arbitration agreement under state law? And two, is the provision that delegates questions of arbitrability or other things clear? And in these contracts, it was. As Judge Pratt explained, it could not be more broad. And there are several cases from Florida, the Third District Court of Appeal that we've cited in our brief, Armis, Krakos, and the other one is Vic Potamkin, which talk about broad language, such as arising out of and relating to, and even go so far as to say that in those circumstances, they can be used to incorporate non-signatories into the question of whether they can enforce an arbitration agreement. And that is a question for the arbitrator under a broad delegation clause like the one in this case. And the other thing that we have in this case, which is very clear in the Florida Supreme Court's Airbnb case, is that both of these arbitration agreements incorporated the JAMS rules. And if you'll permit me to briefly just read what
11B.
11B says, JAMS Rule 11B says, which she agreed to abide by signing these agreements, broadly delegates to the arbitrator all, quote, jurisdictional and arbitrability disputes, including disputes over the formation, existence, validity, interpretation, or scope of the agreement under which arbitration is sought. And key here, and who are proper parties to the arbitration. And so, to us, the inquiry ends there. The court properly decided this was a valid agreement, and then consistent with the clear and unmistakable intent as shown in both the incorporation of these rules and the language that is very broad that we've discussed at length, sent it to the arbitrator to determine arbitrability. And I do, if you'll permit me, want to address the Section 2 argument for one moment. I know we addressed it in our briefs, why we think it's not applicable, but the case New Prime does not stand for the proposition that there is a preliminary threshold determination of arbitrability under Section 2, that a court may not compel an arbitration unless it finds that it arises under the arbitration agreement. That wasn't the issue in New Prime. It only concerned whether a court must initially determine whether the arbitration is excluded under Section 1 before proceeding, which is not at issue here. It's pretty undisputed that this was a contract within the confines of Section 1. So that argument, I respectfully believe, is a non-starter, that the court had every right to otherwise. If we accept that interpretation of New Prime and Section 2, then that basically would displace all these contractually bargained for provisions that delegate arbitrability to the arbitrator, which the Supreme Court has repeatedly found enforceable in the Henry Schein case and the First Options case. So I think taking that to its logical or illogical extension would completely eviscerate all of that very important case law. So, we did put this in the briefs, and you, Judge Traver, you discussed the tipsy coachman argument. While we do maintain that the trial court properly sent this to the arbitrator to determine the questions of arbitrability, on this record, we do maintain that the court can also find that the agreement covers this dispute and with these non-signatories for the reasons that I stated previously. And so if the court has no other questions, we'll rest on our briefs and ask that the court affirm.
One question, Counselor.
Sure.
Could you briefly talk about the second PCA's case and Integrated Health Services? I know that's mentioned in your friend across the aisle there brief. Do you have any way of distinguishing or anything you want to discuss about that case? So
Integrated is an interesting case. If you note, the part that they rely on is in a footnote. So we would, they didn't need to really reach that question, but it is, the court there did say, if I'm not mistaken, I'm trying to find, I don't recall exactly what they said, but basically that the type of language can pertain in any way to the arbitrability. The problem with Integrated, and very respectfully, is I do believe that if it's to be interpreted as they would like the court to interpret it, very respectfully to the Second District, I think that it would probably run afoul of these other United States Supreme Court decisions. And in that case, the delegation clause in that case was not as broad as the two delegation clauses that are at issue here. So that's how we would distinguish that.
And in the four corners of that case, I didn't see, but did you see any mention of the JAMS rules?
No, there's no incorporation that I can see from the case. And so I think that is actually, in addition to the broad language here, as we've discussed, that incorporation is, a clear and unmistakable, two forms of clear and unmistakable intent to delegate these questions to the arbitrator. And I would like to give my counsel opportunity. Do you have any questions for Millennial or? No? Okay, thank you, Your Honors.
Thank you.
I want to just address a couple points. So first of all, the question with a delegation clause, like the question with any other contract, is whether that contract is enforceable. And the court has to decide that question. It's not a super contract where if it's clear and unmistakable, no other contract offenses apply. It's the same as every other contract where you can raise questions about whether non-signatories can enforce it. You can raise questions about whether it's enforceable. You can raise questions about the scope of the delegation clause. And that's exactly what Ms. Wyrick did here. She said the delegation clause, like any other contract, you have to look at whether defendants can enforce it. And the district court, or the trial court, did not do that here. It enforced the delegation clause without considering whether defendants have any authority to enforce it, and that was a reversible error. And you only get to that question about the delegation clause if Section 2 doesn't apply. And counsel raised the argument that New Prime is only a Section 1 case, but if you read New Prime, it is super clear that it is talking about Section 1 as an exception to Section 2, and that Section 2 is what provides the mandate for courts to enforce arbitration agreements, and the court must decide whether the dispute falls within the bounds of Section 2, either because it doesn't fall within Section 1 or because it doesn't fall within the plain language of Section 2 before it compels arbitration. And in New Prime, the court actually cited a 1956 Supreme Court case called Barnhart, where it was a Section 2 case. It was about the plain language of Section 2 and whether that applied. And the court said before compelling arbitration under Section 3 of the FAA, you have to look at whether Section 2 applies. And the court looked at the text of Section 2 and did that analysis. So New Prime is a case about how if the FAA doesn't apply, courts lack authority to compel arbitration. And that's exactly what we're arguing here and what the trial court needed to address. Finally, I want to address the Integrated Health Services case. It was a holding in the case. The court did need to decide whether it could decide the question or whether the arbitrator could decide the question. And it held that it could decide the question. It did put that in a footnote, but it went ahead and decided the question, which is what we're arguing here, that the non-signatory question is for the court and not the arbitrator. And that would not run afoul of Supreme Court precedent. And in fact, many federal circuit courts have held that the non-signatory question is one for the court to decide. And that's because it's a question about whether a contract exists between the parties to the agreement, and that question can only be decided by a court because it's a question of formation. And so and one other thing about this I want to address is the question about the JAMS rules. The incorporation of the JAMS rules is another way that parties can delegate arbitrability to the arbitrator. It doesn't make the delegation that the parties have done in their contract more of a delegation or more enforceable. It is just another way that parties can choose to indicate that they want to have the arbitrator decide questions of arbitrability. But whether they use the JAMS rules or they use explicit language that they want to delegate those questions of arbitrability to the arbitrator, the question is still whether that agreement was formed to do that and whether that agreement is enforceable. And the trial court erred here by not addressing those questions. It didn't address whether the delegation clause could be enforced by defendants who are not party to it, and it did not address whether the parties' dispute about arbitrability fell within the scope of the delegation clauses here, and it didn't address the argument that the active building delegation clause was illusory. And those were all errors because those were things that, whether you look at it as a formation question under Integrated Health Services or you look at it as specific challenges to the delegation clause as a standalone contract, the trial court was required to address those questions either way. And so for those reasons, we ask that you reverse. Thank you.
We appreciate the argument from both sides. The case will be under consideration and will be in recess. Thank you.